Among the most difficult and important things that digital forensic practitioners do is to write forensic reports. Hello, I'm Mark Pollitt, and this video will be about how to write forensic reports. Really doing the forensic examinations is not sufficient. There's an old saying in the legal and law enforcement community that if it's not written down, it didn't happen. Well, that very much is the case when it comes to reporting the results of digital forensic reports. This lecture I'm going to talk about how we can actually write effective reports. I will warn you up front that it is an art as much as it is a science. As the author Stephen Covey said many times in his 7 Rules for Highly Effective People, always begin with the end in mind. In the case of digital forensic examinations, the end will always be, or may always be, a trial. And even if it's not a trial, your audience for your report will be lawyers, prosecutors, defense attorneys, plaintiffs or defendants' attorneys, and effectively investigators and sometimes juries. So you're going to have a number of different audiences for this report, and you're going to need to write a report that gives them the information they need. At the same time, it provides you with the information that you need in order to effectively testify to the contents of a report. Now, as we know from our previous lectures, there are really 4 phases of a digital forensic process, or the forensic process in general. And that starts with the acquisition and preservation of the evidence, the examination of it, which is the nuts and bolts of what you do, the analysis of determining what is important, what is not important, and how it fits into the case narrative, and last but not least, the presentation. And the report obviously fits into this last category. And the presentation, of course, can have 2 parts. It has the testimony part, but it also has the written part, which is the report. And you really produce 4 kinds of products, if you will, for the presentation phase. The most obvious, of course, is the report itself. But as you have already learned, or if you haven't, you will very shortly, the notes are crucial to not only writing good reports, but having effective testimony. And so there is a real interface between notes and reports, and we're going to talk about that somewhat in this lecture. The last 2 parts, exhibits, which are the things that you bring in the trial to demonstrate the results of your examination and to demonstrate how a technology works, will be covered in a separate lecture, as will the actual process of giving testimony. So this particular lecture will focus on the notion of reports and to a lesser extent the notes. Now, we'll start with the notes because you in fact start with them. And while we're going to do a whole other presentation about them, again using Covey's admonition, you need to start with the end in mind, and if you're going to write a report, it has to be based on notes, because anything in the report must be contained in the notes. And the rule of thumb is the notes must contain enough information that a skilled examiner can replicate your results and demonstrate the basis of your conclusions. That doesn't mean that they have to be able to do the exact same steps. It doesn't mean that they have to even use the same software or hardware. What it means is that they can take the evidence that you've had and, using their knowledge, skills, and abilities, replicate the results and, importantly, the basis of your conclusions, if you have any. The notes themselves are discoverable, which means that from the first ink that you put on the paper or the first letter you type into your electronic notes, that starts a chain of events that will ultimately, or potentially ultimately, end up in the hands of opposing counsel. And so it's important that these notes be good, they be clear, they be legible, they be understandable, but they're not in and of itself your report. They're not a part of the report per se, but they are what the report is based upon. Saying it another way, if it's not in the notes, it didn't happen, and if it's not in the notes, it can't be in the report. So everything in the report has to be in the notes. Conversely, not everything in the notes will be in the report. Part of your analysis and presentation process is deciding what is really important and what is not important to answer the questions that you're going to have to answer with regard to your report. Now, if you ever want to start an argument among forensic examiners, bring up the topic of forensic reports, because every examiner has their own view of them, has their own bones to pick, and their own sticky points that they believe in. And there are two kind of main extreme views. When I first joined the FBI, the policy in the lab was put the absolute minimum amount of information in the report. If you could do a report with 1 or 2 lines, then that's what they wanted. That proved to be pretty ineffective and, quite frankly, kind of a waste of effort. As you'll see later on, you really have to have enough information to report, otherwise you're going to find yourself having to verbally give the report over and over again, which increases the chances that you make a mistake. The other extreme, and this was the kind of notion that the IASIS folks, the International Association of Computer Investigative Specialists, when they were doing the very first training in digital forensics, their view was you put everything in there. You put every single step and every single outcome, and you take screenshots of absolutely everything. Well, in the age of terabyte and multi-terabyte drives, A, that's not very practical, and B, it really is producing more garbage than it's producing value. One of the most important things that you do as a digital forensic examiner is to take a large amount of data and distill it down into the important and essential elements for the particular investigation that you're supporting with your examination. So the middle ground is really the important approach, or the appropriate approach, and it means essentially that we have to select what information we're going to include. And when I say what information, that includes what we did, why we did it, how we did it, what the results were, and what our conclusions were. And you want to do that in a clear, effective communication style. In fact, we'll have a separate lecture on communications as well. But for the purposes of this lecture, understand that we're going to be selecting what we're going to include in our report, and we need to do it on some sort of an objective basis. But the bottom line is every examiner has to make choices in terms of what goes in the report. And there is no perfect report, and there is no answer that is correct in each and every situation. And you can have 2 different examiners do exactly the same report, do the same examination, write 2 different reports that they're factually consistent, but are written very differently and organized very differently, and that's okay. In the end, it's about the choices that you make and how you can defend those choices in connection with the goals and objectives for your particular examination. Now, if you stop and think, why are we writing this report at all? And the simple answer is, well, it's going to be the result of your examination. And so what has to be in there? Well, the pertinent facts and conclusions. It means that the stuff that's important needs to be in there. And if it's not a complete report. On the other hand, you can't and should not report everything you did. That's what your notes are for. And most of your notes are not going to be of any interest to anybody. And the report itself is really a legal document. It is a concrete document that provides the basis of your testimony, and it is what the attorneys, the prosecutors, the defenders, the judges, etc. are going to rely upon up until the moment that you get on the stand. And even then, right, if you testify about something that isn't in your report, then you may find yourself in a very awkward position trying to justify things. And I can tell you that anything that is not in the report is automatically suspect. So if you get on the stand and you start talking about something that occurs to you then as really important, but it's not included in your notes, or correction, it isn't in your report, you can expect to get cross-examined at length about that. And the inference is going to be you have to prove that what you did was in fact in there and it was correct and you are reasonable in your belief and have a reason why it was not in the original report. Some cynics would say, okay, well, all reports do is they provide the rope for you for your hanging, and that's really not true. All right. The reality of it is your notes and your reports really are your best friend on the stand, because in the end, right, they provide you with a factual set of information that you can utilize in your testimony so that your testimony is going to be correct. Poor notes or a poor report requires that you rely entirely on your memory and your ability to think on your feet. And in a long testimony, that can be very problematic. So a well-written report may, in many cases, eliminate the need for you to even testify or minimize the amount of things that you are going to have to testify about. And so writing a report well is really an important task, and it's not an easy task. It's a hard task. In fact, in the FBI, it took most people 1 to 2 years to qualify as an examiner. And then it took most examiners about another 2 years to write really good reports without coaching. I would routinely, along with the supervisors who worked for me, read and critique every single report that every examiner would write. And particularly the new examiners, I would spend a lot of time talking to them, and I would virtually debrief them on almost every exam that they wrote. And the issues would get smaller and smaller, and they would get more and more comfortable, and the reports would get better. And generally, after a year or two, they were to the point where I didn't feel like I had to look at them with a fine-tooth comb every single time. But that's having written several dozen reports and getting coached in between. So don't expect in the context of a one-semester course to master report writing. But I'm certainly going to do my best to train you as well as I can in the time at hand. Now, one of the other things that is a personal quirk of me, a sore point for me, is that a lot of the automated tools like NCASE, FTK, iLook, ProDiscover produce what they call, quote, reports. What these are is nothing more or less than a printout of the things that have been done and observed using that tool. And they're useful, but they're not reports in the forensic sense. They are really a glorified form of notes, and I encourage you to use them as such. A lot of people will write their examiner notes in the old days by hand, but now most of the time people do it in a Word document. But they will produce at the end, if they're using one of these automated tools, they will produce a, quote, report from that and attach that as part of their notes. And so it becomes a part of their notes, not the entirety of their notes, and it certainly is not their report itself. Unfortunately, I've seen some lawyers, particularly some prosecutors, that seem to love these printouts, and they tend to rely on them more than your notes or your report. And that's very dangerous for them, and it's a little bit dangerous for you as well. Because first of all, it presumes that they really understand what they're seeing there, which in most cases, frankly, isn't true. Most lawyers do not have the ability to really interpret the outputs from NCASE and FTK without understanding the nuances of what it may or may not be actually telling them. So it's a bad crutch for them, and I think in some cases it's because they have not had examiners write really good reports. And so if you write a really good report with appropriate appendices, they will be less inclined to want to play with your printouts. And in any case, I try to avoid giving prosecutors the raw data if I can, only because they tend to make a mess out of it. So, how do we go about writing a good report? Well, every organization you'll ever work for will develop their own format, and they have their own style and their own verbiage, and so you will learn to write it however they want. To some degree, you'll find that every professor will have you write reports a little differently. In my program, we have tried to standardize it as best we can, but there's always going to be a certain amount of difference there, and that's just par for the course. But we've developed a format specifically for training. Understand that this is not necessarily the best report format for operational reports and real-life cases, but for training purposes, we've defined a report in 6 parts. The first is the examination or validation tasking, and then it's followed up by what we call the forensic questions, then our list of steps taken, our results, our conclusions, and finally our opinions. And I'm going to go through each of these step by step and explain what it is that they mean. This is just a screenshot of kind of the format there. The laboratory number, the date, and the examiner's name are par for the course. You just know what to fill in there. The exercise, validation, test, or examination, pick whatever it is and the number for it and put that in there. Then the first section is examination or validation tasking. And this is a narrative section, meaning that it's a series of sentences, usually no more than 1 or 2 paragraphs, and it is your description of the requirements for this case and what your examination goals are, and if there's any specific criteria that your client wants you to do. And the way we figure that out is we require our submitter, the contributor, the person that's giving us our report or giving us the evidence, they need to, as part of their submission, tell us what it is and what it is they want us to do. It's our job to look at that, talk to them, and essentially put this into a format that allows us to describe what examination we're going to do. And more importantly, it's going to help us define when our examination is complete. Because one of the things that we've learned the hard way, and I've certainly learned this the very hard way, that if you don't define when you're done with an examination, you will never get done. It's much easier to start an examination than it is to complete one. And if you don't know what complete looks like, then you are never going to finish. And so before you even start to do the examination, I tell my examiners to write the validation or examination tasking section so that you know what done means. And I take it one step farther. You should communicate that verbatim with your contributor and saying, okay, this is my understanding of what you want. Are we talking on the same sheet of music? So when I find this and this and this, we're done. Are you in agreement with that? And when you both agree with it, then you can start your exam. But if you start your exam before you come to that agreement, you can get a third, halfway, all the way through the examination, and the contributor says, no, that's not what I wanted. I wanted something different. And that's not very useful. So to really focus the examination, make the examination as efficient a process as possible, and at the same time manage the expectations for your customer so that your customer gets what they think they're going to get, right? You want to come up with a good examination or validation tasking. Now, the tasking itself should say who asked you to do the examination, what is or was their authority or your authority. And this is really important because, particularly in digital evidence, there are lots of parts of evidentiary law that may require some particular permission in order to do something. And so you need to be able to demonstrate to the court when you testify that you had the authority to do whatever it is that you're doing. Now, that authority can come from being a law enforcement officer, it can be from a search warrant, it can be from a court order, it can be from an employment situation, but you need to clearly articulate what your authority was to do that examination. And then, what is it that they asked you to do? And this should be in reasonably layman's terms. Anybody that reads this report, if they're a lawyer or a judge, ought to be able to go, okay, I get what they were asked to do. This is not a time to bring out your technical jargon and try to obfuscate things. Right? It really is a restatement of your examination goals if you do an examination plan, and that's the subject of a separate video. But if you have seen an examination plan, or if you've done one, it really is a restatement of the examination goals. Its purpose is to frame what you're going to do. Basically saying, okay, here are the boundaries of what it is that I'm trying to do, and here's what I'm trying to accomplish. Most people just don't spend enough time or effort on this, and I can tell you that the better you do at writing your tasking, the easier and more efficient your examination process is going to be, and the more streamlined and effective your report is going to be, and more effective your testimony is going to be. And most of all, it's going to tell you when you're done. When you have accomplished whatever the tasking sets out, you're done. It's time to write the report. Here's an example. On 3/1 of 05, Detective John Jones from Tulsa Police Department delivered a 3.5-inch Seagate hard drive, serial number 12345. Detective Jones provided me with a copy of the search warrant, there's your authority, issued by Judge Sally Doe, authorizing the search of this hard drive for information concerning the manufacture, possession, or distribution of controlled dangerous substances in violation of Oklahoma Statute 469-123. And what they're saying here is, okay, this is the kind of information I'm looking for. So if it doesn't help me find information about manufacture, possession, distribution of controlled dangerous substances, then I don't need to look at it. I'm not interested in it. And then the second part is Detective Jones provided the following summary of the case, and in that you're going to get some of the names of the subjects, the locations, perhaps the street name for the drugs, whatever they can give you that will help you to search the hard drive to find information that is probative in this particular case. And then here's where you did your negotiation with Detective Jones. It says, Detective Jones requested an examination be conducted to identify, and you list the things that he wants you to identify. And again, this goes back to the managing expectations. Okay, you want me to do an examination of this for stuff about drugs, that's fine, but specifically what about drugs? What about drugs in this particular case? You really need to refine this down for me, and so you negotiate this back and forth until you and Detective Jones agree on that last statement. And when you agree on that last statement, then you've got a good tasking example. We've had a whole separate lecture on forensic questions, and we're going to go over them yet again on this lecture because they are really, really important. And they're important for you to understand how to think about conducting examinations and how to construct forensic examinations. We learned about Inman and Rudin's typology, where they said they talked about identification, classification, individualization, association, and reconstruction. Well, I'm going to go back and I'm going to cover them very briefly again, but keep in mind that at the end we're going to ask one or more forensic questions in the Inman and Rudin context. Right, in this identification, classification, individualization, association, reconstruction format, right, as forensic questions to help us define how we're going to conduct our examination. Now remember, we talked about identification. It's basically what is it, and merely identifying something as something is sufficient. This is not uncommon in a digital forensic examination, but sometimes it's a little bit more complex than you might think. It's real easy to identify Word documents or spreadsheets or databases or pictures, and if that's all that's required, then that's enough. Perhaps a more focused example would be if we're asked to find child pornography images. Once you identify the photographs and you recognize the content, then it's pretty straightforward. You have identified it. Although, practically speaking, you really can't identify child pornography per se because you're not an expert in the identification of children. Now, it may be intuitively obvious to you, but that may not be sufficient. but being asked to find all of the photographs involving naked people, that would be a pretty easy and straightforward identification task. And so the Inman and Rudin forensic question would be, identify any photographs involving flesh tones. A couple other tasks might involve any images involving sexual content. Identify any references to John Smith, aka Polka's pimp. Identify an invoice dated January 25th. These are specific things that when you find them, that's all you have to do. You're not asked to do anything further other than to identify them. Practically speaking, in digital forensics, that's pretty rare. More often than not, what you're asked to do is some combination of the classification and individualization question. And under Inman and Rudin, the idea is, did these things originate from a common source, and can we identify one or more objects as being the same type of item, or as coming from a particular source to the exclusion of all others? As an example, Word files are a class. We can identify dozens, hundreds, tens of thousands of Word files reliably because we can classify them. We have the software tools that will find every Word file out there, whether it has a .doc extension or not. We can classify them as a group. Now, all Word files don't come from the same source and don't come from the same person, etc., etc. If you want to identify, or correction, individualize a Word file, the only way that you can do that is by running a mathematical algorithm called a hash against it, and if the hash value of a file found on one computer matches the hash value of a file found on another computer or another piece of media, then you can say that those files are identical to a mathematical certainty, and so they are individualized. And as a practical matter, in fingerprints, when we find a loop or an arch or a whorl, that's class evidence. But when we find minutia on there that will allow us to identify that against a known sample, we can then say that we've individualized that fingerprint to this particular subject to the exclusion of all others. DNA, we do that for all intents and purposes, although the reality of it is that DNA is not an exact match, it's just an extremely high statistical probability. Bullets, on the other hand, are, at least to a visual certainty, a fairly exact match, and you can individualize them. But as a practical matter, in the digital arena, we very often classify documents or files in order to look for specific data, and then we look within that data to try to find information of probative value. Occasionally we will be given a known file or some known data and asked to find that in that same location, or find that in our evidence, and in that case we're using individualization. As an example, if you are investigating the theft of intellectual property where some computer code is alleged to have been stolen by one of the programmers, and you can find the known code from the company, and then you look for that same code on their computer, and when you find that same code, then you have individualized that code. And so that's an individualization question in the Inman and Rudin paradigm. Here's just a visual examination of firearms and tool marks, and you can see that they are in fact identical, and therefore that's an individualization. Again, our example, you can find all the Word files on a computer, that's a classification question. And if you can find the make, model, and serial number of a camera used to take an image, then that would be an individualization question. It's pretty hard to do, but sometimes you get lucky. And more commonly, we will take a set of known files, or more commonly a set of file signatures, hash signatures from a bunch of known files, and look for those on our questioned computer, the one we're doing the examination of. And when we find a match to the hash values, then that's individualization. Association is the third element of Inman and Rudin's paradigm, and the idea behind it is that it connects a person to a crime scene or two objects to the same crime scene, and it's based fundamentally on Locard's exchange principle. The idea is that something transfers from one direction to the other direction. And the value of that association is very often measured in a probability weighed against the uniqueness of the elements. Now, if you have, in effect, an individualized evidence, then the probability is extremely high. On the other hand, you can find a number of relatively low probability events and aggregate them, and it becomes more likely as a result of the multiple elements. Examples of these are soils and fibers and glass and paint, where finding a particular set of fibers, particular minerals and soil in one location, while individually they're not rare, the combination of them is relatively unique. So we very often want to associate files with computers, or computers to networks, or computers to emails, etc. And so we typically do that using the metadata, the connection logs, and that sort of thing in our digital forensic examinations. There's just a visual on fiber evidence of different stuff. In a digital forensic examination, you might want to determine if this computer is associated with an email account, PokePimp at IndianMaidens.org. Right? Is this computer done an email? Is it got a email client that has this on there? Is there any email on this machine to or from PokePimp, etc.? Determine if Q1, which is a particular USB drive, was attached to this computer. You're going to do an examination of the registry and see if you can make that determination. Determine if there's any material on this computer that was created by John Smith. And keep in mind that the John Smith is in quotes, because all you may be able to tell is that it says it was created by John Smith. Whether it was actually the flesh and blood John Smith is a different question. And therein lies one of the most difficult of all the association questions for digital forensics. Unlike many of the other forms of forensic evidence, how do you actually prove that a particular human being was at the end of the keyboard? And as some of my colleagues will call it, is the nut behind the keyboard problem. Now, reconstruction is something that's very common in bombing cases. You can see the TWA 747 that blew up over the Atlantic Ocean case a number of years ago. Like all aircraft accidents, they reconstructed it, particularly when there's an explosion involved. But we very often do the same thing in computer incidents, particularly in hacking cases and theft of intellectual property and those sorts of cases. And so it answers the where, when, and how questions. And so we may put together the computer's log files, etc., in order to determine what happened in what order. The reconstruction questions are very commonly done in the context of a timeline. And so, in fact, there are some tools like the autopsy browser that will specifically create a timeline for you. But your tasking may be, in Inman and Rudin terms, to determine the timeline for the creation, transmission, receipt, or any subsequent communications concerning an extortionate email received on January 26, 2002. Basically, how did that email get created, and how did it get transmitted, and how did it get received, and how did it get on this particular piece of media? So when you look at the laboratory report, you see the second section after you do the examination or validation testing to put forensic questions. And unlike the examination validation testing, tasking section, which is a narrative section, the forensic question section are typically listed as a set of numbered bullet points. and they should be whole sentences that typically include the identification, classification, individualization, association, or reconstruction terms somewhere in that sentence. And so it's a succinct forensic question. And again, once you've answered all of those forensic questions, then you are complete. Moving on to the steps taken. This one seems so obvious, but it really isn't. The first thing to be said is that it's not going to be everything that you did. And it may not even be exactly in the order that you did it, but it is in the logical order that will yield the results that you obtained. It's a matter of deciding what you need to say in order for the reader to understand what the result of your process is. And so this is one that you can spend a lot of time kind of playing around with and adding and editing. You don't want to set out every step, but you need to have enough so that not only can you testify, but that somebody reading the report could follow what you did, follow your result, and would be able to go back to your notes and go, okay, I see where they did that particular step. One way to do it, particularly for a complex examination, is to do a flow diagram. You basically set up what you did in blocks, and then figure out what the results are going to be for these blocks, and so put enough data in each of those blocks that you can get to the results that you want to report, and then write your steps accordingly. Again, the steps taken are a bulleted set of numbers. Each item is a complete sentence, subject, verb, punctuation. It is important to do a couple things and not do a couple other things. One, you need to have a consistent way of representing things like file names and computer programs. So if you're going to use a tool, DD, right, you need to have some way of distinguishing that DD is a application, that is a program, and that text.doc is a file, not a set of words. And so a typical way of doing that is by italicizing and bolding things. Exactly how you decide to do it is not the important part, but it's important that you do it, and you do it in a consistent fashion. The second thing is that you do not want to put screenshots in here, and there's a good reason for that, but I'll just leave it at that. Do not ever put screenshots in the steps taken. That's not what we do reports. That's not why you're doing the steps taken. You normally will not put any of your results in there, but you may put a summary. For instance, did a search for Microsoft Word files and found 5,280 of them. That's fine. Don't list the 5,280 here. Don't put found the smoking gun file called gun.doc. Don't do that. You basically say did the search, and if it's useful to provide some metrics for it or whatever, that's fine. But realize that you don't want to make this too complex, but you want to make it sufficiently detailed that the reader or another examiner can go through and go, okay, I see what they did, I see how they got it, and when they move down to the next section, which is the results, they can go back and look at each result and go, okay, that result came from step 4, step 5, whatever. And here's an example. Notice that they're all sentences, and while there is some intermediate results, that's not in sufficient detail to do anything except provide some metrics for the case. There's a lot of confusion between steps taken and results. Results are just that. It is the outcome. It is what happened. The steps taken may report raw data, more likely aggregate data, all right, but the actual results themselves need to be reported in the results section. And this can take a fair amount of organization and structure. This is perhaps the area where you spend a lot more time figuring out how to textually and visually organize the information that you want to report. It needs to be as succinct but at the same time clear. It needs to have some narrative, because you really explain to people what you've got, where it came from, and somewhat what it means, or what the limitations are on its interpretation. But you want to keep it organized, and very often you have lots of bits and pieces, a lot of different files and that sort of thing. And tables are very useful for that kind of reporting. And so there's a great deal to plan out with regard to that. You know, this is a very simple one here, but there were 26 graphic files identified which appear to be children. They've been placed on a CD-ROM, marked ECF, provided the contributor. Well, that's okay, but you probably want to do something a lot more extensive. You can number, you can do numbered bullets, you can do sections and subsections, and you can include tables. Organizing this is up to you, but again, you need to put the actual data in there, but at the same time, you need to organize it. Excuse me. In the directory C/documents and settings, Roger marks my docs. A set of files which constitute a website was located. These files, when viewed in a web browser, advertise the sale of chemicals used in cocaine processing was located. The website's metadata indicated the site was developed by use of Microsoft Office Publisher, a copy of which was installed. You can see that you're providing raw data, but at the same time you're also providing some context. And here's an example of using tables in there. And here's the files that you found, and the file created, modified, and last access time. Conclusions and opinions. These are two separate sections. Not only are conclusions and opinions two different things, but they really have two different levels of proof. In the case of conclusions, what you're essentially reporting are scientific facts. There are things that you can demonstrate based upon your results that, to a reasonable certainty, can only have occurred in the way that you report. On the other hand, opinions are based in part about experience. And so if there are alternative explanations for how something might have happened, then it is probably an opinion. If it's provable, then it's a conclusion. One bad thing to do is to make investigative conclusions. Well, I think the investigator ought to do this, or, you know, I think the bad guy did it. Those are investigative conclusions and have no basis in scientific fact, and so they shouldn't be in your report at all. And so conclusions are scientific conclusions, and opinions are opinions based upon the science and the experience and training and education of the examiner. And obviously this is where they go. And here's an example. Based on a comparison of the website located these two sites are identical. All right, that's a statement of conclusion. That's a conclusion. This conclusion is based upon the file names, the sizes, the mathematical signature, and direct comparison of individual files. That forms the basis of your conclusion. The data is these files. Your conclusion is that these are in fact identical, and the basis of your conclusion is because you did the following things and gives you this result. Are there any alternative explanations for this? Not really. And so this is a reasonable conclusion. Now, opinions, on the other hand, are a little bit fuzzier. Now, An example in this particular case is based on the examination of the subject's computer, the internal clock, the dates, the times, etc., etc. It is my opinion that the subject's computer is most likely the source of the email received by the cooperating witness. That leaves the door open to the fact that are there alternative ways that these things could have happened, and the answer is yes. And so as a result, it's fine to put the opinion, but you still need to provide the basis of that opinion, which is all this data that you outline in this example. And while you don't have to list the alternative explanations, kind of unspoken is the notion is that there are alternative explanations. And so you probably may want to record what you think some of the alternative explanations might be in your notes, just so that you remember why you put it in an opinion instead of a conclusion 3 years after you wrote that report. Remember, the forensic questions are based on the tasking, and the tasking is based upon your negotiation with the contributor. The steps taken are driven by those forensic questions. Pretty much the forensic questions will lead you to say, this is what I need to do in order to conduct my examination and to get the results that I need. The results are the data that are obtained from your doing the steps that you did and the steps taken. The conclusions are the scientific facts that you draw from the data that you got in your results. And the opinions are logical inferences from the data in your results and your opinions, and provide for a reasonable belief by the examiner rather than a scientific fact. Report writing is an art. It takes lots of time and experience. It requires careful consideration of all the issues, technical and legal. You're going to need to edit and re-edit and rewrite time and time again. You need to keep in mind that whatever you finally submit, you are going to have to live with on the stand. There are no do-overs in this case. And so always from the beginning of any examination, think about it with the end in mind. Think about everything that you do. How am I going to put this in my report? How am I going to explain this in my report? How am I going to testify about what I write in this report? Well, that's it for this lecture, and so I hope you've enjoyed it, and I hope you've gotten something out of it. Until next time, have a good day.